All right, good morning. A few notes on the midterm. 0 people have come to see me so far. The number is 0. A couple people have emailed me, said they're going to, but so far 0. I need to provide more incentives. I'm going to make a cutoff. That's only if the students respond. If you'd like for me to go over your midterm, you need to finish reviewing it, let's say by, I'll say by November 8th, right? It's basically 3 weeks from now. 1 second. If you want me to review it by November 8th, that's your deadline. My office hours are right after this class. I'm also usually here from about 2 o'clock till about 4 after the class. I'll be here this Friday for most of the day. If you want to come by on Friday, you can come by, stop by. You don't need to make an appointment. If you want to, you can, but just stop by. I'll be here most day Friday. I think on Friday, I have a thing at lunch around noon, and something I'm doing for the 1L, like a 1L scheduling faculty thing at like 3, but I'll be here most of the day, so just stop by. Please print out your exam, but by the 8th will be the last day that I'll be able to go over your exams. After that, you guys are on your own. I'm disappointed. I thought more people would come see me yesterday, but no one did, or I think on Tuesday. Okay, but I'll be here Friday, probably around 10 or so, and I'll be here most of the day. So just come on by. Yeah, Nolan.
Do we need to email you a copy?
Please don't email me a copy. Just print it out and come. The reason why is I have 110 students, and I can't do 110 attachments. It's just too complicated. Also, the advantage is you print it out. I can actually like write notes on it and like say, here's what you did that's right, and this is wrong, and maybe move this around. It's you get to bring them a prop, right? You get to bring them like a demonstrative device, if you will. It's like something you can actually take home with you. So please, yeah, I've done in the past with the emails, and I get so many damn attachments, I lose them. And everyone names it like midterm final, no, midterm.doc, and I have 100 midterm.docs. I can't remember who's whose. Makes my life easier. Okay. All right? Make sense? Okay. All right. Let's start our class today. We're moving on to a new topic that will occupy us for a couple classes. And this topic involves the due process clause of both the 5th and the 14th Amendments. This is a different area, right? We just finished the decisions from the Reconstruction period, like Slaughterhouse and Cruikshank, civil rights cases in Plessy. And all these cases read the Reconstruction Amendments very narrowly, right, to protect a very small set of rights and to not provide any sort of guarantees of equal protection under the law to people in the United States. The cases in today's class are kind of different, right? And the reason why they're different is like, how can it be that you have these blatantly racist laws that the court says, yeah, that's fine, right? Yeah, separate but equal is okay in train cars, right? And then you have a law in New York that says you know bakers can't work more than 60 hours a week, right? How do you go from Plessy saying that that law is okay to Lochner saying, oh no, you can't tell the bakers what to do? And I don't have a good answer for you either. I know people ask that question every year. I don't have a very good answer. I know it's not satisfying. But what I want to try to convey to you today is how thinking shifted about the 14th Amendment, right? The precedents from Plessy and civil rights cases and Slaughterhouse, those are precedents the court does not want to revisit. They're okay with those precedents. But during this time, in the 1870s and 80s, there were really no cases about the due process clause. As a result, the court sort of used the due process clause to accomplish what other provisions were intended to solve. That is, the court used the due process clause to protect a right to contract. And you might recall that was one of the rights the butchers asserted in Slaughterhouse. And in cases like Buchanan against Warley, the segregation case we'll do later today, the court used the due process clause to eradicate segregation Well, Josh, isn't a segregation law a violation of equal protection? Yeah, I think it probably is. But they couldn't given the precedent. So when you think about the cases for today and due process, you have to understand them in the context that the court was sort of cabined, they were controlled. They didn't have the votes to sort of get rid of the old cases from the 1880s. Only Harlan would have dissented on those. But they still recognize that there are other sorts of rights that can be protected, but they did it by due process. All right, so everyone just get the journal frame, right? Just keep that in mind as we go through the lecture for today. All right. I want to start off by talking about a story that you may have read called The Lottery. Did anyone read this in high school? Anyone read it? Okay. Okay, so if you don't give it away, okay? So the story goes like this. You have a town, a very secluded town, right? It's a small village, only a few hundred people. And every year they assemble for what they call the lottery. And they do the lottery every year to try to ensure there's a good harvest. That's their tradition. So the lottery works like this. I'm going to just summarize it a little bit. Every family is selected, and they go to the town square, and they pick a little piece of paper out of this box. And one of the pieces of paper has a little black mark on it. Okay. So every family takes one slip of paper, and one of the papers has a black mark on it. Okay. Then there's a second round of the lottery. All the people in the family who select that black slip go back to the town square, and they each pick a slip. So let's say there are 5 members of the family. Each of the 5 members picks out a little slip of paper. Okay? So in this family, Tessa, the mom, was the one who went there, and she picked out the paper, and hers had a little black mark on it. Okay, so she won the lottery. What happens to her? Everyone in the town stones her to death. Well, you didn't see that coming, right? Now, Josh, why am I giving you this story? What the hell does this have to do with Lochner and bakers and butchers, right? Well, this is a good illustration of the concept of due process of law, right? Who's next? Yeah, Ruben. Yeah, you get a good question, right? Was the lottery that I just described to you fair?
Doesn't sound fair.
Why not? Tell me why.
Because I guess not everybody was treated equally.
They all had an equal chance of drawing the paper. There was no cheating. It was random. Everyone had the same odds of slipping the paper.
It was the townspeople that were.
Yeah, everyone in the town has to draw a piece. Every family drew a piece.
About like the leaders.
Yep, they were.
Okay, everybody. Okay.
Everyone in the town has to do the same procedure. That might not be true, but I'm just making it up for this for hypothetical. It's my hypo.
So equal treatment sounds fair.
Yeah, I think Jessica, you next.
Yeah.
Jessica, is this lottery fair? You don't need to do the poll question. It's not necessary. Maybe I'll do it later. But Jessica, is this fair?
I would think so. You didn't say that she protested it before when it wasn't.
Oh, so she was cool in years past when everyone else got killed, but it was up for her. She start complaining.
Yeah.
Yeah, and I think in the story she says something like, "It's not fair," as she's getting stoned to death. Katie, is this thing fair? What do you think?
I don't think so, because you're depriving that one person of their life just because everyone else.
But was she?
To give everyone else something.
But can't. Okay, so I think you said 2 things that are important, right? So first, she's being deprived of her life. Was she given any sort of process before she was deprived of her life?
I mean, what kind of process?
Oh.
Procedurally, she was given a process because you have to go get the ticket, but.
So I think Katie said a few things I want to just focus on. So she said she was given some process, but what kind of process was it? Was it the process that you're due before being executed? In other words, can you just walk into a court and the jury flips a coin to decide guilt or innocence? I think I gave this question to someone last class, right? This is, I guess, a little bit better than a coin flip because everyone had an equal chance, right? Now, you said the second thing you said also. What was the second thing you said?
To give everybody else something. So everyone
Yeah, right. So again, the reason why they do this lottery is to help the harvest, and of course we can say that's total bogus, right? That's not actually a thing, right? You don't increase harvest by murdering people, but that's what they believed, and people believed if we don't do this harvest, we'll have famine, we'll have starvation. So maybe the state has a compelling, strong interest to justify this deprivation of this woman's life. And also, again, every year someone else gets murdered, and they keep doing it. Well, so what do you think? Is this thing fair? This lottery system?
Philosophy that's kind of like pretty comps to being fair. You have like equality, you have need, and you have deservedness. So I mean, under like equality, it was fair. Everybody had the same chance, but she didn't really deserve that. There was nothing that she did wrong.
Usually I ask, what does it mean to be fair, right? If you have a son or a daughter or little siblings, that's something kids always know. Like, Mommy, that's not fair, right? Daddy, that's not fair. Kids always say that. How do kids even know what fair means, right? He's like, oh, you're not treating me equally. Well, this is equally. Now, Leslie says fairness is premised on what you deserve. Does a person who draws a slip of paper deserve to be murdered? Right? I don't need you to answer this question. If you want to think about it more, you can, but I just called on a few people to get a sense. This issue tees up what due process of law means, right? What does that mean to have due process of law? Does it simply mean that any process can be used before you're deprived of your life? Or is there some specific process? Is there some process that's due, right? What process are you due? That's what the phrase means. Is there a process that you're due, that you're entitled to before? But it's not only about due process, it's due process of law, right? Of law. And what does this phrase of law means? There has to be some rationality to it, right? The very definition of law is that it's non-arbitrary, that there's a reason, that there's a rationale, that there's some justification to explain why is the state doing this, right? Why is the state doing this? So I gave you the example in this situation. This town decides we need to murder a person every year to avoid famine, to avoid starvation. I think everyone in this room would agree that that's absolutely insane, right? That there's no conceivable basis, right? There's no rationale where that could possibly be accurate. Yet they all voted for it, right? The town leaders, I'll just take Ruben's question, right? I'll make this up. The town leaders and the members of the government voted for it, right? Let's just say it's a direct democracy. Everyone in the town approves of it. Miss Tessa, who got murdered, was okay with it last year when it wasn't her, right? In fact, I'll even make it even more obvious. Every year they reauthorize it, right? Every year they yep, let's do the lottery again. Let's do it, right? One of the points that Randy sorts of pushes, and I'm growing increasingly sympathetic to it, is the idea that not all statutes are laws, right? Not everything that's voted upon can be called a law if the law has no rationality to it, no sense to it, right? That it's not enough to have your process that's due, but it's a process due according to a law. And if this ordinance, this village procedure, is so irrational, so arbitrary, it cannot be called a law at all. Okay? Everyone with me? That's the basic argument about substantive due process, right? The idea is there's some liberty, or it's some life, or there's some property that's important. And before that life, liberty, or property is being taken away, the government must act according to law. Substantive due process says that this word liberty has substance, has meaning. And the court's going to decide what that meaning is. And once the court decides that this is a liberty protected by the Constitution, they can assess whether the law itself was valid, whether the law used to deprive you of that liberty was reasonable, was it rational, right? That judges can come in and assess the wisdom, the validity, the rationality, whatever word you want to use, of the law being used to deprive you of your liberty. Now, we can all agree on the lottery case, right? If some village decides to enact a lottery law, and then Miss Tessa goes to court and says, Your Honor, can you please halt the execution right? This law is completely random and arbitrary. I think everyone in this room would agree, yeah, okay. The judge can say, you know what? You are being deprived of your liberty. You're given some process, but it's completely random. This process is not according with law, right? It's not a process that's consistent with the law, because the law has to have some rationality to it. I think everyone agrees with me there? No? Oh boy, Tanner, you're shaking your head. You know, stone away? Gopher? Why?
Well, because you have to point to like a higher authority in order to say that the will, like of the people is wrong. And so, unless if they can point to a like higher authority, like a constitution or some morals or something.
Well, but what about the Constitution? It says due process of law. Is that not clear enough for you? Do you think that the random ticket drawing from the lottery safe is according with due process of law? The answer could be yes. I mean, because it's a process established according to law.
Yeah.
That's one perspective, right? What Tanner articulated is what you might call procedural due process, right? The idea that as long as this law was passed by the requisite process, right? The town council voted on it, maybe the mayor approved it, whatever the process is according to law, that's all you get. And if the members of that town agree that you only get to have this little piece of paper drawn, that is what the law establishes, right? That's what we call today procedural due process. The progressive era courts, though, did something different. They engage in what we now call substantive due process. By the way, these labels did not exist in the 20th century. These are early 20th century. These came around much later, around the maybe turn of the century, give or take, right? Procedural due process is what Tanner said, right? This law was passed by the town council, approved by the mayor. Okay, that's enough. You get whatever process is according to law. Now, if, for example, someone rigs the ballot, right? They put extra slips in there with a little mark in it. Okay, then you're denied your due process, right? Because if they rigged the process, or maybe someone in the town didn't pull the paper, right? They pretended they didn't do it, right? Okay, then there's a problem. As long as you adhere to the process, you're good, right? Excuse me. Thank you. The Lochner style court, though, does something different, right? They argue that the courts can assess if the law is reasonable, right? Again, so I think most of us would agree this law has no rationality. Maybe not. I shouldn't speak in broad strokes. I apologize, Tanner. But when we get to a case like Lochner, we get a lot more division, right? In a case like Lochner, we're not only dealing with, murdering a woman for drawing a piece of paper, but a question of how many hours bakers can work per week, and if the state has enough of an interest in protecting workers or perhaps stifling competition, right? So the specifics of substantive due process are often controversial, right? How do judges know whether a law is reasonable? How does a judge know whether a law is rational? What evidence can they rely on? Can they second guess the legislative process that created these laws? The opposite perspective is, screw it. So long as a law passes through the requisite checkpoints, that's all the court can ask for, right? If the law is adhered to, if the law says you are tried for guilt by flipping a coin, and it's a fair coin, it's not weighted, right? They're not like, you can make these coins that flip always heads or always tails, right? It's a fair coin. Or maybe you roll a dice, right? You roll a 1, you get 1 year. You roll a 6, you get 6 years, right? Whatever it happens to be. That's it. That's all you get. Anyone else want to weigh in on the lottery? It's kind of like a gruesome story, and so yeah, Katie.
I'll just say there's a movie that's really nasty too.
What
I watched
based on the lottery? No, I've not seen the movie. Should I watch it?
Yeah, I think it's from the 80s.
Oh, really?
But it's pretty I might not, don't quote me on that. It's an old movie.
I see 19. Okay, I think there are a couple of versions of it.
The one I watched is pretty.
Uh,
Now, if people watched it, they'd be like, oh, whatever. But back then, when I watched it, I was like,
Scary. All right, well, I'll check it out. Thank you for that, Katie. Yeah, Nolan.
So, me and Tanner were talking about this earlier.
Oh, that makes me happy.
Just because, I'd say it's fair, right? The lottery's fair. Everything about it is fair. But just because it's the law, or a legislator or a majority decides this is what we're going to do, does that make it just? Does that make it right? And so that's my issue with it. Like, fairness is one thing.
Well, but the courts have the power to set aside laws that are not just.
I'd have to say yes, because in the lottery, just because everyone agrees doesn't mean the law is right or just. And just because it's fair doesn't necessarily mean it's right.
Well, let's take a poll. What the hell? I don't know. Again, I'm not going to look at your results later if I don't care, but I think usually this is pretty one-sided, but maybe you guys are more divided. I don't know. Is that a hand?
I would say that it's not fair because one family loses their mother, everybody misses. And one family loses the child, everybody misses.
But what if now the town won't have famine and that everyone can survive? This is like the classic dilemma, right? If one person's murdered to save the rest of the town, right? Let me give you another example, right? You're driving down the street and you have a choice. You can either swerve one way and hit a child, or swerve the other way and kill an entire bus full of people, right? This is a classic dilemma, right? You're driving down the street and you have a choice. You can either swerve one way and hit a child, but if you go the other way, you're going to kill an entire bus full of people. I'm sorry?
I said it's actually a movie, something like that.
Yeah, there are movies for everything. This is actually non-trivial with self-driving cars, which are a thing now. You have to code that, right? That if there's a Tesla going down the road and it has a choice to swerve one way and kill a child, swerve the other way and kill an entire bus full of people, right? And you can make that split-second decision. So I mean, the thing that Angela raising is not like a hypothetical. This is like you stone Tessie, and then you get no famine for the year. Again, that's not real, but this is what the people believe. Can a court tell people you guys are insane? That's not right, which is the question Tanner raised, right? Can a judge come and say, you know what, you people are nuts, right? What you voted for is just batshit, right? You can't do that. How's a judge to know? No, New York, you can't tell the baker so many hours to work. Yeah, Soros, go ahead.
I would go with the St. Augustine.
Oh boy, we're going deep now.
An unjust law is no law at all, because I mean, yes, it's fair, but is it a just law? Is it rational? Does it make sense?
And then judges have to decide what rational means. All right, let me just. I think just put your votes in, please, if you want. I'll give you a couple more seconds.
It's saying we are talking.
All right, whatever. Well, I have 30, which is I think more or less a plurality of the class. Let's see what we got. Wow, that's actually. Well, you'll find when you do surveys if sample's good enough. So if there are 30 of you out of 40, that's close enough. So about 60 of you thought it was fair. Wow, okay. You know what? Every class is different. This is usually like 80-20 the other way. But okay. Maybe because it's 9 a.m. I don't know. You're all very dark in the morning. I don't know. Okay. But I don't mean to impugn those who put this was fair. I think you're adopting what you call procedural due process. It's about deferring to the democratic process. If the democratic process wants to do X and they have the votes for it, they can do X. I mean, that's basically what you're subscribing to. It's also the belief that judges lack the wisdom to perhaps come in and second guess the decisions made by others, which is not a trivial concern. You'll see in cases later this semester where the court says the people are wrong. They didn't know what they were doing. They were bigoted. They were racist. They were homophobic. They were misogynistic. Whatever label you want to use. And then the dissent, usually by Scalia, says, "Who are we to say? Who are we to say whether the people are right or wrong when there's not a clear textual command?" Right? When there's something clear, right? First Amendment, right? Commerce Clause. Like, okay, is this commerce or not? Like, we can actually have a debate about that. But when we have this language, due process of law, do we go to St. Augustine's, right? Do we go to the Leslie? What was that the three modes? I can't remember. I never took philosophy. I don't know, right? But the three philosophy things, right? How are judges philosopher kings? Are they religious patrons who have to study scripture? How can the judge know? You're all sitting here. You're all soon to be lawyers. Maybe you'll be a judge one day, right? What is it that I'm teaching you that would allow you to make a judgment of what's right and wrong? I don't think I can teach you that. My goodness, I wouldn't even try to. Some professors do, I'm sure. I don't. That's a deep question that's beyond my ken. I wouldn't. I don't know. I don't have that capability to teach you what's right and wrong. Yes, Mr. Hen?
I think a lot of people chose fair because it's fair until it begins to hinge them. And once it
Oh.
it's unfair. So
Yeah.
if it's conditional like that, then it shouldn't be fair.
So once you draw the paper with the mark on it, then it's not so fair anymore.
Exactly.
It's cool. When someone else getting stoned, it's cool.
Yeah, but not me. Oh wait, no. We can't
Okay.
make this process.
Fair point. Yeah.
I just think the question is asked, like, lottery, is the lottery fair?
Fight the question,
It's not
okay.
right, so it may be fair, but it's not like.
You know, maybe I should ask it. Just one at a time. I love conversations. If you want to just raise your hand. So maybe I can phrase a question next year. Could a court stop this? In other words, could a court find this violates due process of law? Maybe there'd be a better way of asking it. Okay, I'll think about that for next year. Yeah, thank you, Amy, and then Nolan.
Because I mean, I've got sure, but it's not simple and dark or gloomy or anything. It's just, the question read literally, like, is it fair? Everybody has an equal chance of drawing a paper. It doesn't make it right, but like I don't think
Okay, I'll consider next year maybe tweaking the question. I think Nolan, was your hand up?
It was basically like then, like, does fair here necessarily mean right or just? Like, fairness is relative. In
Yeah.
a sense, like,
Okay. I think you've persuaded me. I think maybe next year I'll ask it like, does the lottery violate the due process of law? Something like that, maybe. I'll let that one. Okay, I'll think about it for next year. Okay, fair point. I think Ray, your hand was up.
I think it's fair because the family chose to live in this town.
Oh, they couldn't exit. Yeah, if they didn't like it, they could have left. I mean, that's a federalism type argument. If you don't like the laws, go somewhere else. Yeah? Yeah, folks.
Is it a universal definition of fair? Because you put it.
Boy. Yeah, well, that was part of the thing. What does fair mean? This was Leslie's philosophy thing, right? What does fair mean? There are a lot of ways of defining fair. There's just not one way. And I give this deliberately. I frame this vague deliberately, trying to get people thinking, but maybe I should be more precise. I don't know. I'll think about it for next term. Again, I'm not going to judge you on this and like report you to the bar. They think this is fair, right? Look, I think people have different perspectives. I think you got a very good range of views here. Yes, Nick.
Just my 2 cents is like comparing the death of this one girl to the alternative, and if the lottery was for a good harvest, they don't get a good harvest, and famine and everybody dies.
I'll say they got a good harvest.
So yeah, one death.
Do you assess the fairness after the harvest comes in?
Well, assuming that it is good, right?
Yeah, it's
That's
great
what
harvest.
For, so
Yeah.
yeah, like one death is worth everybody else living, I think. So when you weigh it to the alternative, yeah, it's fair.
You know, this is like I'm going to call Nick, I'm going to move on, but this is like the Jack Bauer hypothetical from the show 24. Could you torture one person if that person has the code to stop a bomb from blowing up, right? You know, this is, Scalia wrote about this in some opinion, right? Could you, if one person had the code to stop a nuclear bomb, could you torture this person to get the code out? I mean, you're shaking your head, yes. If they don't get the code, then the entire city's wiped out. Yeah, Nick, last comment, then I'll move on.
To feed off of you, what if killing that one person creates a good harvest 65% of the time? Is that fair?
Well, let me actually, yeah, let me take Nick's point. Let me build on this, right? How certain does the government have to be to act, right? If the government says we think that working 60 hours a week is probably safe, but there's a 10% chance it will lead to illness, 20% chance, 50% chance, right? In other words, how correct must the government's evidence be, or how certain must the evidence be to justify this law? The government says, you know what, this has never happened before, but maybe someone might inhale too much flour and they'll get sick, right? We have no evidence of this, but it could happen, right? Can the government just make crap up to justify law and say, well, this might happen? And does the court then defer to it? Or can the court say, you know what, this law makes no sense, but maybe something could happen? You know, maybe bakers can start inhaling too much flour, I don't know, and that's dangerous, right? We'll uphold the law on that basis. So the question of proof becomes very important. All right, let's move on. Okay, and this discussion always takes half an hour, I know, but I think it's worthwhile to get you guys thinking a little bit. Today we have a few classes that seem kind of scattered, don't they? Right? They don't seem to line up, right? The first case about the railroad, then the second case about the bakers, then the third case about the segregation law, then you have the minimum wage for the hour law for women, and then you have seemingly the opposite way with the minimum wage for women, right? All these cases focus on the due process of law. Let's start with the first case, Chicago, Burlington, oh, it's got such a long name. Chicago, Burlington, and Quincy Railroad Company versus City of Chicago. Okay, so Colby, let me ask you a question, please. let's just do a review. What was the holding in Barron versus Baltimore?
Oh, that the Fifth Amendment didn't apply to the states.
Yes, that the takings clause of the Fifth Amendment did not limit state power. Okay, and Kobe, let me ask you one question. What was the holding in Cruikshank? Good review. Very good, thank you. You got 2 for 2. Excellent. In Cruikshank, which I think was 1886, might be off by a year or two, Cruikshank held that the Bill of Rights, the first 8 amendments, still did not limit state power. In other words, that the Bill of Rights only limited federal power. So despite the enactment of the 14th Amendment, the states were still free to restrict property rights, for example. But then we get the Chicago case, which is a little bit different, right? The Chicago case doesn't overrule Barron v. Baltimore, doesn't even mention it. The Chicago case doesn't overrule Cruikshank, it doesn't even mention it, right? This case was not premised on the Privileges or Immunities Clause. Instead, the case was premised on the Due Process Clause. All right, Jason, you want to run me through the facts, please, in Chicago Railroad case? I can't remember the name; it's too long. Chicago, Burlington, and Quincy Railroad. Go on.
The city of Chicago, they want to join two cities together. So in order to do that, they have to take some property owned by some individual and also the Quincy Railroad. And I think they challenged the statute, and then in trial, I think the railroad got $1 award.
Yep.
And they appealed it, saying the statute is not valid as the process.
Okay, very good. Thank you, Jason. This was a fairly common case in the late 1800s and early 1900s. Railroad companies were becoming very popular. It was like the most popular method of transportation. And the city would often use what's called eminent domain to take property and build railroad tracks over them. Here the city seized property, but the jury only put the compensation at $1. The Fifth Amendment says compensation must be just. It must be just compensation. So here the question is, was this $1 compensation just? Was it just within the meaning of the Fifth Amendment? Now, the court doesn't really even talk about the Fifth Amendment. They don't talk about Barron or they don't talk about Cruikshank, right? Is that Vanessa? No, you're Vanessa, sorry. Would you want to just walk me through the court's analysis, please?
Yeah, they talked about the 14th Amendment instead.
Yeah, well, which clause in the 14th Amendment, be precise?
The due process.
Thank you so much, okay. And the opinion here is by Justice Harlan, who you know, I'm a Harlan fan, right? Explain Harlan's ruling to me, please.
He says that under the 14th Amendment, there has to be due process of law before you take away property. But he didn't really go into whether the $1 justified the
Okay. Okay, very good. Thank you so much. Justice Harlan explains that this case turns on due process of law, right? That the property owners cannot be deprived of their property without the due process of law. Okay? And Harlan says the process to take property is very specific. In order to take property, you have to be given a process that offers you just compensation. Again, the 14th Amendment says nothing about what processes do when you take property, but Harlan says it's a matter of right that when the government takes your property, they must give you compensation, right? That is the process you're due, right? This is the question before. What kind of process is it? Harlan says to take property, you have to give compensation. Now, how does Harlan know that? Well, maybe you say he looked at the Fifth Amendment, maybe he's cheating a little bit, but also in virtually every state in the country, there's a long, deeply held tradition of giving compensation, right? Harlan would say this is a fundamental right. What does it mean to be fundamental? You have this deeply rooted right and tradition, right? That this is what all free governments do, and Chicago must do the same. Okay? You need compensation to comply with the due process of law. Right? He says also you have to have some sort of hearing in a court to show why there's a public use. There has to be some sort of process. And if you have a taking that does not give you compensation, it violates the due process of law. Sounds good, right? Now, Vanessa, we get to the end. It's kind of just like like it goes off the cliff a bit. How does Harlan end his opinion? It's sort of weird.
He goes on to say that a statute or law can authorize the taking of property.
But
But
what about the $1 here in this case?
he didn't address it.
Was the
He said
$1 sufficient?
He just said that pecuniary compensation should be given, and then didn't address the $1.
Yeah. Well, let me explain why this is, right? He's not taking property 2 yet. In property 2, you'll learn about something called an easement, right? Railroads did not actually take your property. They wanted what's called an easement, which is just the right to build a road across your land. The inconvenience here is probably very trivial, right? So Harlan probably said, well, $1 is enough, right? And there are other cases, people shaking their head. You'll see cases where $1 judgments were upheld. There's a famous case called Loretto, where the city of New York required the installation of cables along buildings, right? And these cables were used to transmit TV signals. And eventually the court said $1, and that was enough. You're shaking your head, no? No? You don't like $1? No. You want more money for that? Exactly. Nominal. I think that's exactly right. The court's saying, well, we have to at least establish that there was a taking, but you weren't really deprived of your land, so $1 just to give you enough, just to show that you lost. But I think nominal is the correct word. These were nominal damages, right? Because the burden was priced slight. You got Justice Brewer dissenting, saying, whoa, what's going on here? Right? We just said we have to protect this right, and then you get only nominal damages, which is not enough. Okay. Now, why am I giving you this case? It's not a hard case, but it shows that at least in this time period, the court was identifying what processes were due before you deprive someone of their property, right? What processes were appropriate. In other words, it wasn't enough that the Chicago government said we're taking your property. They had to act according to law. They had to act according to some process that was established by law. In this case, $1 happened to be enough. But maybe in another case, $1 was not enough. But the government can't just say, okay, for all takings we give $1. The compensation must be just, it must be appropriate. Here, they said it was appropriate. That's why we put this case in your book. I didn't used to teach it, but Randy likes it, so I started teaching. I think it's good. Okay, questions in the first case? No? Okay, let's move on. All right, the second case is a much bigger deal. Now, you're somewhat either spoiled or deprived, not sure which word. Most law professors very much dislike Lochner. Many law professors think that Lochner belongs the anti-canon along with Dred Scott and Plessy and Korematsu. I can explain why, but I'll first tell you why I think that's unfair. You have cases involving slavery and Japanese internment and segregation, and then you have a case about bakers. I have just never been able to get worked up at Lochner like most law professors do. I'll explain why, though, in a minute. My law professor was David Bernstein, who wrote the definitive book on Lochner, so I think I'm spoiled. But for many law professors, Lochner represents how you should not go about judging. Why? In Lochner, the court basically told New York, you're wrong, right? You thought this law was reasonable, we know better, right? You thought you needed to restrict the hours of bakers to 60 hours a week, we know better. This is not a reasonable law, you guys are a bunch of idiots, right? This is, I think, Tanner's point earlier. Who are you to say that this law is unreasonable, right? If we decide we want to protect workers' health, why can't we do this? And Lochner came to be a symbol of what judges are not supposed to do, right? You might hear the label judicial activism. It's a label I will never use again because it's not very helpful. What's an activist opinion? It's an opinion you disagree with, right? When a judge does something you don't like, you call it activist. There's no meaning. It's a meaningless term. Justice Holmes, the dissent, might be called judicial restraint, which means you defer to the democratic process, right? You don't get involved in second guessing the wisdom of the legislature. Now you may say, of course, the court shouldn't second guess the wisdom on a baking law, but we'll do later cases involving, I don't know, laws banning contraception. Do we second guess those laws? Laws banning sodomy, can the state make that decision, right? There's violating some unwritten right to homosexual sex, right? In a Lawrence case, right? Does that warrant courts intervening? So invariably, some people like intervention in these cases, but not in those cases, right? Some people say across the board, yay, courts, go second guess the legislature. Other people say, courts, stay back, don't get involved, let the political process work. Most people are in the middle. It's like, well, I like this case, but not that case. And that's fine. There's nothing wrong with that. But to recognize why the Lochner case has become so wildly opposed. Okay? Questions so far? Yeah, I can't see anything. Oops. Yeah, Caitlin. You want to give me the facts, please, in Lochner against New York?
So Joseph Lochner was convicted of a misdemeanor for violating New York's Bake Shop Act because he wrongfully and unlawfully required or permitted one of his employees to work more than 60 hours in a week in the bakery.
Okay, very good. Thank you. All right. New York enacted a series of laws known as the Bake Shop Act. The Bake Shop Act. Most of these laws were not particularly controversial. And in fact, the court upheld almost all of them. So for example, one section regulated drainage and plumbing of bake shops. Another section regulated how high the ceilings had to be, right? That you couldn't put animals on the floor, huh? Another one regulated having washrooms, and that you couldn't sleep in the bake shop. Another section said that the bakeries can be inspected. Another section said you have to get some sort of notice provided when you alter the facilities. Now, you think, Josh, why was this such an issue, right? Animals, you can't sleep in the bakeries. Why was this even something the government cared about? Well, let me explain. Today, when you think of a bakery, you think of this sort of commercial institution. It's very sterile. Right? Everything's made of metal. There are people there with these little, their little hair bonnets. They're wearing these white coats, right? They work 8-hour shifts. It's very clean and bright. At the turn of the century, right? At the turn of the century, bakeries were very different. Many bakeries were run by immigrants, and they weren't run in these sort of bright shops. They were run in basements. Okay, why were bakeries run in basements? The ovens used to bake bread are very heavy, right? Very heavy. If you try to put an oven to bake bread on a first floor, it will fall through the floor. So the only floors that were strong enough to actually support these ginormous ovens were usually in basements of buildings. There are no basements in Houston, but they're very common elsewhere, right? In a house with a first floor, it'll fall right through. Okay, what about sleeping? Baking bread is a somewhat unique task because there's a lot of waiting, right? You made bread before, right? You have to knead the dough and let it rise for a few hours. You got to sort of knead it again, let it rise for a few hours. You have to let it bake for some time. You have to let it cool, right? So there's a lot of intensive work and then waiting, and intensive work and then waiting. If you have a big bakery, you can have just someone around the clock just kneading, and then you have just sort of waiting. But if you have a smaller bakery, you do some work, then you have a break. Then you do some work, then you have a break, right? Many of these immigrants work then as today around the clock. And if the bread needs to rise for an hour, they'll go take an hour nap. And so that sometimes they didn't have beds. They would sleep right there on the floor. They did what they had to do. What about the animals? Well, cats are very good at catching rats. And they serve a very important function in a bakery because they can keep away pests and vermin to keep the bread cleaner. Okay? Now, these immigrant bakers were not very popular because they were usually not unionized. Most of the bigger bakeries were unionizing at this time. The immigrant bakers, they couldn't afford to unionize, too expensive. They couldn't afford the dues, they didn't want to get their salaries cut out. These sorts of laws that were passed in New York had multiple purposes, right? On the one hand, they were there to protect health and safety, which people think generally is a good idea. But on the other hand, they were designed to put small bakeries out of business. Why? If you were a small bakery with an oven in your basement, you could not comply with this law. It was impossible. You couldn't. If this law went into effect and you had a small bakery, you were now out of business. So who supported this law? Well, you had the sort of progressives who favored health and safety, and then you had the unions, and you had the bigger bakeries who supported this law to put their competition out of business. This is a very common concept in economics. Anyone ever hear the phrase Baptist and bootlegger? Anyone ever hear this phrase? Baptist and bootlegger? All right, I'll give you an example. You've heard it? Okay. During Prohibition, right, who favored banning alcohol? Two groups. The Baptists favored banning alcohol because they thought it was sinful, right? All right, the Baptists don't drink. And their justification was pure because this is the scripture, right? Who else favored banning alcohol? The bootleggers. Why? Because they can jack up their rates. When you ban something, it becomes more expensive. They can open up the speakeasies, right, and these gin mills, and they could sell moonshine out of a bathtub, whatever the hell they're doing, right? So in economics, most regulations have these sort of Baptist and bootlegger coalitions, where you have people supporting a law for good reasons and people supporting a law for not so good reasons, right, because it profits themselves. Same here, right? Who supported the Bake Shop Act? It was people who wanted to increase health and safety. But also the bakeries that were unionized who wanted to put their competitors out of business. That's just how things worked. The Lochner case arose as a test case. Joseph Lochner owned a bakery in upstate New York, and one of his workers, whose name was Amon Schmitter, brought the case. Right? This was totally, they were in cahoots, right? Basically, Lochner told Schmitter, you have to work more than 60 hours a week. Schmitter wanted to. This wasn't like a setup, right? He wanted to do it. And as a result, Lochner was prosecuted for violating the Bake Shop Act because he had his worker go more than 60 hours a week. Right? Again, you could have actually worked at 2 bakeries for 120 hours a week, but you can't work at 1 bakery for 70 hours a week, right? So this was, the law didn't really do much, but it was one employer, 60 hours per week. All right? So what happens? The court upholds almost all the Bake Shop Act. Now, I know they uphold the thing about the plumbing and the drainage. They uphold the painting of the floor, no wood walls, the washrooms, the animals, the bakery inspections. They uphold everything. However, the court splits 5 to 4. 5 to 4 on the most important provision, which is the hour law. Right? The 60-hour-week limit on working. They split 5 to 4 on this. There are 3 opinions in Lochner, and I want you to make a very clear note in your outlines about the 3 opinions here, because they make a really huge difference. You have the majority opinion by Justice Rufus Peckham, P-E-C-K-H-A-M, Justice Rufus Peckham. You have the first dissent, joined by 3 members, written by John Marshall Harlan. Yes, the same Harlan we've studied before. He was a very influential justice, which is why I'm such a fan of his, right? Most justices, you don't know their names. You should know the name John Harlan. I mean, you should know all their names, but if that you actually really need to know the names. You know Harlan, right? You know Marshall, you know Story, you know Jackson. Most of the justices are not very important. You can forget their names. Like when I was doing this book, if you go to the back of the book, we list all the justices with their where they're from and what state who appointed them. There are 120 or so justices, 117. I knew probably 70 or 80 of them, which is sad. I don't even know most of them. Justice Gorsuch tells this great story. He clerked in the Supreme Court for Justice Byron White. And you have no idea who Byron White is probably. He was a remarkable human being, Justice White. He was in the NFL. He was a leading rusher. He won the Heisman Trophy. He served overseas in war. I think he served overseas in war. He graduated. He basically was at Yale Law School, took a year off to go to the NFL. The guy was just remarkable, right? He worked for President Kennedy. He was desegregating the South as an assistant attorney general. Served in the court for almost 30 years. You've never heard of him, Byron White. The guy was huge. He was like a beast. He was like a real athlete. He actually was a leading rusher, had the highest salary in the NFL. I mean, just remarkable guy. One second. Never heard of him, right? So here's Gorsuch's story. When Gorsuch was clerking, he would walk around the hallways of the Supreme Court where they have all the portraits of the justices. And Byron White tells Gorsuch, when he was a clerk, how many of these people do you actually know? And Gorsuch says, well, do I lie or tell the truth? Tell the truth. I know half of them. And then White goes, yeah, me too. And even now, White died in the late 90s. People forgot him. Just doesn't have any salience. So most of the justices just are not very memorable. They're important so long as they're casting a fifth vote, and after that, they're not important anymore. But then some of them, like Harlan, right, or a Story, or a Marshall, or Robert Jackson, I'll put Scalia on that list. People will be reading them for 100 years to come. Yeah.
Kind of going back to the case before.
Who's Justice Brewer? David Josiah Brewer. My goodness, right? From Kansas. Who the hell is he, right? Exactly.
Is that a nephew of Justice Field, or was I mistaken?
Is that right?
Yes, because his sister, Justice Field's sister, is married to. Brewer's
I
mom.
didn't know that. I did not know that.
Actually, Field lived with Brewer's parents while they were in Greece.
I had no idea. Thank you. I didn't know that.
Yeah, because I was going back and I just was interested because somewhere I was reading that they were like serving together and they were uncle and nephew. And I was like,
Yeah, by the way, I think Justice Brewer did not participate in Plessy, if I remember that right, because he had to go to a funeral or something. Anyway, so, I mean, random stuff. We had 2 Justice Lamars. Did you even know that? Do you even know we had 1? We had 2 Justice Lamars. My goodness. Yeah, I mean, just most of these people, if people serve for 20, 30 years, they just have nothing of salience that we remember anymore. It's kind of like, we're all dust in the end, but just you're a Supreme Court justice, right? My goodness. And then just no one knows who you are. Yeah.
On the bakeries, is it fair to say that they were in a very similar stage as Upton Sinclair's The Jungle?
Oh, that's a good point. You may have read about the Jungle in your studies, about the meatpacking facility. There were dirty bakeries for sure. Lochner's bakery, though, was actually not dirty. In fact, in your book, I have this picture, which I found this, and Randy ripped it off from me. I was actually kind of annoyed at him. Right? I wrote to the Utica Historical Society and said, "Do you have any pictures of the Lochner bakery?" And they sent me this blurry photocopy. I was like, "Oh my God, I found this thing!" And they put it on my blog, and it winds up in Randy's book, and it basically crops out where my name is, right? So screw it, my name's in the cover now, I win, right? But you have this Lochner's bakery for cleanliness and stuff. Now the Lochner bakery apparently was in good shape. I mean, there's a picture of it. Looks nice, right? It's in upstate New York. I've never been to. Oh, I'm going to Cornell next week. Maybe I can visit it. How far away is it? I'll check that later.
There's a bit of
Yeah, I think. Is it near Syracuse? I'm going to Syracuse also.
Yeah, it's near.
Oh, maybe I'm going to do a road trip.
Close to
It's the Matsuyo Indo of bakeries, right?
Yeah, right? I like that.
Bring back some bread.
Yeah, and when I was in law school, I had a debate on Lochner and I actually had pastry served. Okay, it's nowhere near where I'm going. Oh, well, it's kind of, no, it's not even close to me on the way. Yeah, I'm from New York City, Staten Island, New York. We don't ever go up there, so just this basically Canada. It's called, there's upstate New York, but there's no downstate New York. There's like an upstate Illinois and downstate Illinois. There's no downstate New York. It's not a thing.
If you talk to someone from upstate New York, they'll tell you that
Yeah.
upstate New York doesn't start until Albany.
Yeah, they don't like that. Yeah, they're very strict. Okay. Back to the case. So there are 3 opinions. First by Justice Peckham. I think this is only real major opinion I can even remember. The second is by Justice John Marshall Harlan. And the third is by Justice Holmes. Holmes is another name that you should know. He was a giant of his time. The Peckham position got 5 votes. The Harlan position got 3 votes. And the Holmes position got 1 vote. I'll tell you, my friend, the Peckham position is no longer good law. it isn't. But it was important during the progressive era because it prevailed in a few cases, like Adkins. The Harlan position was good law for some time until the 1950s. And the Holmes position, although it got only one vote, is more or less the law we have with us today. And specifically, these are all the approaches to reviewing economic regulations, like in our law. You'll see later we have cases involving personal freedoms, contraception and abortion and otherwise. Those cases took a different path. So when I say that Holmes is good law today, I'm only referring to sort of economic cases. In the early 20th century, they didn't draw this distinction between personal cases and economic cases. That didn't exist, but today Holmes has prevailed. So what I want to do is, I'll call on Jamie next. Jamie, I want to talk about the three approaches, Peckham, Harlan, and Holmes. Let's start with the majority opinion. How would you characterize Justice Peckham's approach to reviewing the Bake Shop Act?
So he was saying how he was going to have as though there were ulterior motives.
Ooh. Why does Justice Peckham think that this law was enacted, Jamie? Was it to protect the health and safety of the people?
No, because 5 out of 6 of them were pretty in-depth or like very direct in accordance to like health.
Right.
But the hours were not.
And I'm sorry, Jamie, let me ask you a follow-up, please. How does Peckham know that this law, which restrict the hours you can work, won't possibly help people be healthier? How can he actually say that? He's very confident of this fact, but how does he know that this is not actually about helping people?
Is it because going back to how you were saying how you could work 60 hours in one, but then could work 60 at another?
Well, that's good. That's good. Nancy, what kind of evidence does Justice Peckham bring to show that this is not really about saving bakers' lives and not making them healthier?
Is it when he talks about other cases about vaccinations and
Okay, give me a little bit more.
So he uses an example of a case where it says that the state had the proper exercise of the police powers of the vaccination because if not, it would affect like everybody else.
Okay, but my question's a little different. My question is, what evidence does he show that bakers can work 60 hours without a problem?
I know he talks about like the mine and workings.
Oh, okay, good. So a little bit more on that. I think you're on the right track.
So like he explains like whenever like mine workers where they're in a situation where it can be hot and like.
So does he think that baking is a dangerous profession compared to mine working?
No.
Okay. So here he's making a bit of a generalization, right? A bit of a rationalization. He says, look, there are some dangerous professions, right? If you're working in a mine shaft, right, the state can restrict your hours. That's dangerous. If you're going down the mine, the canaries are chirping, then they're not chirping, you're in trouble, right? You can suffocate, there can be a cave-in. But this is not a mine, this is a bakery, right? They're baking bread. How dangerous can it be? And he actually brings in statistics showing that this isn't so dangerous, right? That among various professions, bakers don't have, lower life expectancies in other vocations, right? My favorite line is about the lawyers, like, can you imagine restricting the amount of hours lawyers could work? Get used to it, guys, right? You think your hours are rough now? Just wait. Seriously. You think coming to class is hard? No. This is easy. There's a plan. You do one class, next class. When you're on your own, you're on your own. No one's telling you how to go about structuring your life. But Justice Peckham says that the state's police power is not absolute, and that the state's police power is limited by this right of contract, right? This liberty of contract. The same right that butchers asserted in Slaughterhouse, the same right that Myra Bradwell asserted in her lawyer case, right? Those same rights are now being protected by the Due Process Clause. Okay. Questions so far on Justice Peckham? All right. The court also introduces what you might call means and balancing. Means ends balancing. And the court does this a lot. Let me try and explain this to you. I think I've done it a few times before. The court will often consider whether the government's actions are reasonable. And how do they do this? They say, well, what is the government doing here? They're restricting hours to 60. Okay. And why are they doing this? To promote public health. Okay, so they ask, does limiting work hours actually promote public health, right? Is there a good fit between the means, the work hour limit, and the ends, health? And Justice Peckham says, no, the fit's not good, right? There's not enough evidence to show that having the 60-hour limit will actually make workers healthy. And because there's not an adequate fit, this law is unreasonable. Therefore, it's an act for other motives. All right, that's Jamie's point a minute ago. Right? If the law actually did what it says it's going to do, then we don't have to question the motivations. But because the law is not actually doing what it says it's doing, we say, well, why are they enacting it, right? See the sort of scrutiny, right? Think of it in a lottery case. Why is the village enacting this law? Is there actually going to be the chance that murder... Excuse me. Why did the lottery town enact this law? Does having this law actually make a better harvest? Of course not. That's freaking insane, right? That's nuts, right? That's not going to happen. So maybe they're enacting it for another law. Maybe they have a bloodlust, right? Maybe they like to kill people, right? Maybe it's good for sport. I don't know. But the rationale they're using is not the rationale they give. Think of Yik Wo, right, from last class. Why did San Francisco enact this ordinance? Was it to promote safety? No. There's no connection between having a license and being a safe laundromat. They did it to punish Chinese people. They didn't like Chinese immigrants. That's why they had the law, right? So you see this, it's a sort of this process, right? You ask, does it make sense? Is there a fit between what they're doing and what they say they're trying to achieve? If there's not this sort of connection, then we ask, okay, why are they really doing this, right? What's their real motivation? What are they really up to? Oh, I see. They want to punish Chinese laundromats, right? Oh, I see. They want to shut down the immigrant baker shops, right? Right? That's what they're really getting. Oh, they just want to murder people for fun. I don't know, right? You ask these sorts of questions. And the entire idea of substantive due process is judges engage in this inquiry. Now, Tanner says, and about 60% of you apparently, maybe, Tanner says, no. Judges should not be in that business. If the law goes to the checkpoint, the legislature passes it, the governor signs it, that's all the process should do. And that's more or less the Holmes position, right? I'll get back to Harlan in a few minutes. Let's do Holmes now, right? What does Justice, Nick, what does Justice Holmes say in his solo, you can flip ahead, that's fine. Justice Holmes say in his solo dissent.
Yeah, I kind of felt like he thought they shouldn't really get involved that much.
Yeah.
One of the things I highlighted was I strongly believe that my agreement or disagreement has nothing to do with the right of a majority to embody their opinions in the law.
Perfect. That is Justice Holmes in a nutshell. Just read that one more time, please. A very good sentence here, Ed.
I strongly believe that my agreement or disagreement has nothing to do with the right of a majority to embody their opinions in the law.
Right. This is exactly the point Tanner raised earlier. Sorry, I keep picking on you, but you made the point early about the lottery. If the majority votes for this procedure, right, the majority votes for this procedure, who are we as unelected judges sitting in this ivory tower? Actually, it was marble, but you know, this marble building, right, to decide if it's rational or not. Right? Who are we to decide? Right? Whether or not I agree or disagree is secondary. Right? Holmes was a very famous proponent of judicial restraint. Right? He firmly believed in deferring to the democratic process. In almost every case, there are a couple exceptions which we won't study in this class, but in almost every case, Holmes said, we'll go with whatever the state says. In almost every case in this topic, Holmes dissents. And in the case where he didn't dissent, he had to draft dissent because he couldn't get any other votes, right? But in almost every case in this topic, he's a dissenter. So at least the guy's consistent, right? I think give him that for consistency. We'll do cases in the future where you're not so happy about Holmes. For example, we have a case called Buck v. Bell, where the state of Virginia wanted to sterilize women deemed imbeciles. He says, who am I to judge? Oh. He's like, who am I to tell the democratic process is a bad idea? That's basically what he says. So the Holmes, like, yeah, go Holmes. Holmes, right? Holmes is a conflicted figure. Like, I think, people don't, he's hard to get. There's a lot going on there. He was a remarkable human being. He served in the Civil War. He was shot twice and survived both times. Most people are shot once and they die. He was shot twice and survived and went on to have an established career. He was a state judge. President Teddy Roosevelt put him on the Supreme Court. He lived till his 90s. He died in 33 or 34, might be off on the year. But he was a remarkable judge. I can't stand it, but I have to respect his legacy. It's stunning. But I think Nick stated the Holmes' opinion correctly. He had also a few other famous lines. He writes, "This case is decided upon an economic theory which a large part of the country does not entertain." He's effectively saying the majority is not doing law, they're doing policy. They are favoring some kind of capitalism as constitutional law. That the Constitution says nothing about a right of contract. It says nothing about liberty of contract. That the police power of the state is absolute and it can shut down businesses as it sees fit. He writes, "If it were a question with whether I agreed with that theory, I should desire to study it further before making up my mind. But I do not conceive it to be my duty because I strongly believe that my agreement or disagreement has nothing to do with the right of a majority to embody your opinions of law." This is Nick's quote from a minute ago. I think it's exactly right. Right? States can regulate life. That may seem unfair. But courts can't come in to interfere with that. He then writes, "The 14th Amendment does not enact Mr. Herbert Spencer's social statics." Who the hell is Sir Herbert Spencer? He was a philosopher, an economist at the time, who wrote about laissez-faire, not laissez-faire, but it was a form of capitalism. I don't want to bore you with the details, but he was basically targeting laissez-faire capitalism. He also writes, "If we can compel people to be vaccinated," which was another case, "then we can compel people to work only 60 hours. Okay? Ultimately says, "A reasonable man might think it a proper measure on the score of health." Think of a reasonable personal standard in torts, if a reasonable person can find this law reasonable, that's enough for me. Holmes once famously said in a letter, "If my fellow citizens want to go to hell, I will help them get there." And he believed it. He said, "It's not my job to be your better." Again, you can agree or disagree with Holmes, but he was the most eloquent and articulate advocate of this perspective from the early 20th century. He had some good First Amendment cases that went the other way, where he found a broad protection for free speech, but those are a bit of outliers. Okay, so questions on the Holmes opinion. Again, he was solo. It was only one vote. No one else joined him. Yes, sir.
I'm kind of having a hard time understanding how he juxtaposed judicial review with his right of letting the legislative branch do whatever it wanted, as long as it was.
Well, when you say judicial review, that's a broad term, right? I think how Holmes would respond is, if there's some clear prohibition in the Constitution, okay, the courts can intervene. But when you have this sort of vague, nebulous standard of due process of law, whatever the hell that means, liberty, how are judges to know? So in other words, if there's a clear violation of the Constitution, right, the city took someone's property and didn't give any compensation at all, I think Holmes would go along with it, right? you know, police did a search without any warrant. Holmes might go along with that. You know, the state banned a religion. I think Holmes will go along with that. You can stop it. But here it's vague, right? It's not clear what liberty means. You'll see Scalia channel Holmes quite a bit in some of the cases involving substantive due process. But the criticisms of substantive due process were forged by Holmes back in the 1900s. Any other question? We'll do a lot of Holmes. It's even later today. Yeah, Nolan, then Nick.
So, what exactly is the court's role in Holmes' eyes?
Well, lots of disputes are not constitutional, right? There are common law torts. There are common law contract disputes, right? The court resolves a lot of cases that don't involve the Constitution. Holmes was fine to interpret statutes, but Holmes was saying constitutional cases where the allegation is that something's unfair or unreasonable, the presumption should be the government wins, right? There should be a presumption of constitutionality. And when I say presumption of constitutionality, it means the court should presume the government's acting lawfully, right? I don't even know if Holmes could let you rebut that presumption. I think Holmes would say, so long as the law passes through the government, you know, legislature, governor signs it, that's it, unless there's a clear prohibition otherwise.
But isn't that why the court was established?
Says who? To say that in the Constitution?
Wasn't that our founder's intent?
Says who? Says who? Hamilton? That nationalist, right? Not everyone agrees, right? The Constitution from the first day of class we talked is silent in the issue of review, right? What does that mean? Even John Marshall, I think, was far more restrained than people give him credit for, right? Marshall didn't identify made-up rights in the whole cloth. He said, okay, is this commerce or it's not commerce? We'll decide what commerce means. Says who? Who says judges do that? I mean, you might like that role, but is Holmes necessarily wrong? Right? Does Peckham have any stronger claim to the Constitution than Holmes does? Nick?
You have a sentence in your supplement that kind of confused me.
Oh, what I write? It was Randy's sentence, I'm sure. No, go ahead.
Maybe you could dumb it down for me because I couldn't really understand it. It was Holmes charged the majority with deciding upon the economic theory which a large part of the country does not entertain.
Yeah.
Namely laissez-faire capitalism.
Yeah.
What is he saying? I didn't really follow that.
Do you know what laissez-faire capitalism is?
Yeah, it's like where the government kind of stays out of it and lets the market kind of.
Right. Okay, thank you. Yeah, Randy and I fought about that sentence for a while. I know that sentence. Seriously, I know every sentence in the book. I think the entire damn thing by heart. It's scary. Laissez-faire capitalism. Laissez-faire is a French word, which basically means hands off, right? The government does not put their hands in the economy. Holmes was asserting that the majority was not doing common law. Holmes said the majority is doing economics. And Holmes says that the court is substituting the Constitution and they're putting in its place economic theory. In other words, if a law runs afoul of laissez-faire capitalism, it violates due process. That the court's confusing the 14th Amendment with Mr. Herbert Spencer's social statics. And that was a charge about laissez-faire capitalism. People often say Holmes was talking about social Darwinism, the survival of the fittest. It's not quite right. And in fact, Holmes himself was a Darwinist, as we'll see with the sterilization case. Does that clear up a little bit? No?
So, well, I guess specifically it says a large part of the country does not entertain.
Well, Holmes says that not all Americans favor laissez-faire, right? In New York, if people favor laissez-faire capitalism, they could repeal the statute, but they didn't. They enacted a statute to impose these regulations.
So I guess my thought is if most of the country doesn't want this idea of laissez-faire, why not get involved? Like, if he acknowledges the country doesn't want that, and he's like saying.
Well, if the country doesn't want it, then the court should not impose it. Right? If the people of New York like this regulation, then they should be allowed to have this regulation. That's what Holmes would say.
Yeah.
And the majority says, well, the people of New York are wrong. They're stupid. Right? They're acting unreasonably.
Okay.
They're violating this right that they don't even know what they're doing. Right? There's this deeply held right, and the people of New York have just gone off the rails, and they're doing this new thing. Okay? Let's do the Harlan opinion. Who's next? Jonathan. Now, Harlan had 3 votes. I mean, Harlan's position is one I usually associate with. I think it's probably the best one in the case. Here, Randy and I don't agree on Lochner. He's with Peckham. I'm with Harlan. So we don't even agree on that much. This is one of the few areas we disagree with. Maybe with most of. So walk me through the Harlan opinion, please, Jonathan.
Harlan attacks a lot of the points that he brings up, having
Good.
So he brings up like all the like health violations kind of that like a baker or like all like kind of how why being a baker is dangerous, like working extra hours for the like shouldn't be allowed because he says that like getting flour, like working with flour, like it gets in your lungs get inflamed, and all sorts of statistics like that. While hours should not be allowed.
Okay, good. A few things about Harlan, right? Harlan agrees that there is a right of contract, right? He agrees that this right exists, right? He agrees that the 14th Amendment protects the right of the bakers to practice their trade, right? That much is easy, right? That this right does exist. But he doesn't apply the same test the majority does. He applies a different test, right? The majority puts the burden of proof on the state, right? Peckham says, New York, defend your law. Show us why your law is reasonable. Harlan flips it. Harlan says, bakers, show us why the law is unreasonable. See the difference, right? The majority puts the burden on the state to show that their law is reasonable. Harlan puts the burden on the bakers, on Lochner, to show that the law is unreasonable. Let me tell you something. When you're in court and you have the burden, you're going to lose. Right? If you're in court, you want to shift the burden to the other side. Because whoever has the burden usually loses. Because you can never actually satisfy your burden all the way. Maybe you can, but it's hard. Right? By putting the burden on the bakers, Harlan flips it. And he gives this test. Right? This is a little bit of a long test, but I'll read it for you. It says, if the end which the legislature seeks to accomplish be one to which the power extends, and if the means employed to that end, although not the wisest or the best, are yet not plainly and palpably authorized by law, then the court cannot interfere. Again, if the end is legitimate and their means are reasonable, that's enough. Right? In other words, does imposing an hour limit increase bakers' health? Maybe. Good enough. Do you have to actually show it's improving their health? No. But if it's a reasonable supposition, that's enough. In fact, Harlan does has contrary evidence showing that bakers are a dangerous profession, that there is health risk associated with the job. Right? He has counter evidence that Justice Peckham puts forward. Right? So in this case, the statute was enacted to protect the health of those working in the bakeries. Whether or not it is wise is not for the courts to second guess, not for the courts to inquire. Right? In other words, the fit between the means and the ends does not have to be as tight. If there's some general relationship, a reasonable relationship, or a rational relationship between the means and the ends, between the 60 hours and the health, that's enough. Right? There has to be some evidence, right? Holmes would say, I don't need any evidence. Holmes would say, does it make sense? Was it enacted? Sure, that's good enough for me. Harlan's like, okay, let's actually look at this. Is there some evidence to show the fit between the means and the ends? Yes, you're home free. The majority says, no. There's got to be a really close connection. You have to show me that that bakers are actually a dangerous profession, and that this is necessary to help them. Right? Is it necessary, or is it just reasonable? Right? Peckham, Harlan, Holmes, 3 different approaches. Right? Peckham would put the burden on the state to show that the law is necessary. Harlan puts a burden on the bakers to show that the law is unreasonable. And Holmes says, whatever. The law was enacted, that's good enough for me. Right? And I think there are pros and cons to all 3 of these approaches. The Peckham opinion would more or less be the rule throughout the Progressive era until the New Deal. After the New Deal, the court more or less agreed with Harlan for a while. But after the 1950s, the court, in economic cases, moved to Justice Holmes. So Holmes got the last laugh. Right? As we go through the cases in this unit, I always want you to think back to those three opinions, Peckham, Harlan, and Holmes, and see who are they like, who are they associate with, who are they similar to. And I'll refresh that one. Yes, Braden?
How long was the Peckham opinion used for, you were saying? Or how long did that
There's not a fixed answer because we'll do Muller in a few minutes, but they didn't really stick with that one, right? But generally, the Peckham opinion was acceptable until the New Deal. And after the New Deal, it went away. There are no fixed years, which Randy and I struggle with this, like until this year, until that year. So we just give general eras. It's easier. Because the courts aren't always consistent. Right? The court will go back and forth on different cases. Okay. Questions on Lochner. Very important case. And if you want to read more, I gave you a little excerpt from the book Rehabilitating Lochner by my former professor. Read that. It gives you a good flavor for the case. Anything else on Lochner? Yes, sir. Sergio.
So Holmes he's basically a proponent of like deferring to the people, like to the democratic process.
Yes.
And like the judicial out of it. Is that way of thinking basically saying that I guess a person isn't allowed to contest whether a statute is law?
Unless there's a clear standard in the Constitution. Again, if there's an easy one, they took your house, they didn't pay you for it, I think Holmes would say you can't do that. Right? There's a clear violation of the Constitution. But when we're dealing with terms like due process of law, whatever the hell that means, I think Holmes would be a lot more stringent. Right? Again, if there's like a breach of contract, Holmes is your guy, right? He'll litigate that. If there's a tort, he'll litigate that one. He was a very, very influential common law judge. But in the specific context of the due process clause, he was very rigid about deferring to the democratic process where the Constitution's silent. Right? How do we know what due process of law means? How's the judge to know? Right? I can't teach what that means. I can't teach what fair means. I wouldn't even try. I'm not a philosopher. Judges should not be philosopher kings. I think they are sometimes, but they're not. They're not putting people are not putting the bench because they're the wisest. Right? They're not putting the bench because they're the smartest. Unfortunately, why are people judges? They're politically connected, right? Whether it's an appointment process or an election process or federal, it doesn't matter, right? There's an old joke: how do you become a judge? Be roommates with the governor in college, right? Right. We have one of the Fifth Circuit nominees who is being voted on today. He was appointed probably because he was roommates with Mick Mulvaney, who was the OMB director, right? People are not put on the bench because they're smartest or the wisest. And you should remember that when you read their opinions. They're not there for that reason. Now, many of them are very smart, and many of them are very wise, but that's not why they're put there. There are other reasons. We do the best we can with them. They don't like when I say that, but it's true. There are very many smart judges, and some aren't so smart. You can pick and choose. Okay. All right, any other questions on Lochner? Let's jump into Muller. In the next edition of the book, Muller will come after Lochner. I don't know why Randy put it there, but it's in the wrong place. All right, so Lochner was it 1905, right? And then we got Muller 3 years later, 1908. I was at the Supreme Court Historical Society does these reenactments where they actually reenact a famous case. And they get a lawyer to argue for both sides. And they get one of the justices to preside. When I was in law school, Justice Ginsburg presided at an argument from Muller against Oregon, which is pretty cool. And you actually had arguments from both sides arguing that the women maximum hour law was valid. And what was hilarious was during this argument, Justice Ginsburg was saying, well, counsel, what about Lochner, right? If the bakers have a right to work 60 hours, why don't the women have a right to work 60 hours? Whatever it was. And it was just hilarious because you kind of juxtapose the right of the butcher, I keep saying butchers, slaughterhouse, the right of the bakers versus the right of the launderers in the Muller case. It also brings to mind Slaughterhouse and Bradwell, right? Decided back to back. In slaughterhouse, at least 4 justices thought the butchers had the right to earn a living, and the very next day, that almost all of them thought that the women had no right to be a lawyer, except for Justice Chase. Okay. So, Dylan, you want to give me the facts, please, in Muller against Oregon, 1908?
So, Oregon passed a ordinance that said females could work more than 10 hours a day.
Uh-huh.
And then Muller was charged with.
I think it's Muller.
Oh, Muller was
Yeah, I think it's pronounced like the special counsel, Muller. I think it's pronounced the same way, but go ahead.
So Muller was charged with female employees working more than 10 hours a day.
Good.
And there would be a majority opinion on these kind of complete differences between man and woman.
Very good, very good. Well, let me just pause here for a minute, right? This was not a law that regulated any particular profession, right? The New York law limited only the profession of baking. This was a law across the board that said women can't work more than 10 hours a day. Now, this often gives students difficulties. Like, on the one hand, you think, well, that's nice, you're protecting women from abusive labor practices. But on the other hand, this was not applying to men, right? And the reason why this law was enacted was based on, I don't have another word, a sexist view of equality. Is that a good word? I don't have another word for it, right? It was basically the idea that women were inferior, and if they worked too much, it would injure humanity. I'm not exaggerating. This case involves a very famous brief filed by Louis Brandeis. Louis Brandeis was a very famous progressive litigator. And Brandeis looked at the Lochner case and said, aha, they're citing all these statistics about how baking is healthy or not healthy. I'm going to do something better, right? I'm going to submit a brief to the court explaining why we need to have special laws protecting women. And this became known as the Brandeis brief. There were no legal arguments. There was no law in there. The entire thing was this compendium of studies and statistics and social science, and it was junk, right? I don't know how to describe it nicely. It's just, even for the time, the stuff in there was quack science, it is. One of my favorite lines, and I'm not making this up, you can go look it up, it's in the video, was where Brandeis writes that women have more water in their blood, so therefore they can't work as many hours. Okay, I guess. There's another argument that was raised at this time. This is actually serious. That if women worked too hard, their uteruses would fall out. Okay. Yeah. It was nuts. But the court needed that argument to distinguish away Lochner, right? In the same way that Bradwell went against women as being part of the home, home and they're not in the kitchen, right? Muller needed those sorts of arguments to distinguish away Lochner. In other words, the bakers in Lochner had this right to work, but but the launderers in Muller did not. And the physical differences between men and women justified this disparate treatment, right? So the court upheld the maximum hour law for women, but they declared unconstitutional the maximum hour law for men. Okay, Muller is not really good law, but it kind of is for reasons I'll explain in a minute. Okay. Any questions on Muller against Oregon? Okay. We have 2 more cases to study. The next one doesn't really fit anywhere. I don't know where to put it in the book. It doesn't fit, but I think it belongs here. And it's Buchanan against Warley, right? Mitchell, you want to give me the facts, please, in Buchanan?
So there was a house being sold, and there was a seller who was a white person trying to sell to a person who was a black person, and there was a state law for the benefit of public health and safety. And the ordinance is that
Good.
So, it violated, the seller asserted that the ordinance was, unconstitutional because it violated the 14th Amendment.
Okay, good. So let me ask Amy a question. Amy, why couldn't Buchanan and Warley litigate this case based on the Equal Protection Clause of the 14th Amendment? Why would that not have been a successful approach? Why couldn't they go and argue that this Louisiana law, I'm sorry, this Louisville law violated the Equal Protection Clause?
That wasn't really what was at issue.
I know it wasn't. I'm asking why it wasn't.
I mean,
Why would that not have been a winning argument in 1917 to argue equal protection? I see you whispering. Yeah. It would not have been a winning argument. What precedent would have made that a losing argument? Mitchell? I saw you whispering it.
I was just saying they were racist.
Oh yeah, well, I mean, okay, fair. But there's a case I'm thinking of. Yeah, there you go, Plessy. Thank you. Oh, that might be true, but Plessy, yeah, okay, Plessy. Plessy had separate but equal, right? This was literally a separate but equal statute, right? Instead of having separate train cars, you had separate neighborhoods. It was literally a separate but equal statute. Amy, I'll come back to you in a minute. You're not yet. They could not argue based on equal protection. They would have lost. They say, well, separate but equal. Instead, they argued based on the Due Process Clause. And they argued that this law deprives you of property without due process of law. Now, again, this law was enacted. The legislature approved it. The governor signed it, right? It was enacted, but they're arguing this was not really a law because it was irrational, right? Maybe because it was racist, but also, who can tell me where I can buy property, right? Is this arbitrary? Okay, so Amy, walk me through the majority opinion, please.
Okay, so he's basically saying that common persons who adultery have the same contracting abilities as a white person.
Yeah, yes. But how do they know that the 14th Amendment protects a right to contract? How do they know this? Right? Isn't this Holmes' argument that we don't know what the 14th Amendment protects, so we're just not going to talk about it?
Well, they said these enactments did not deal with the social rights of men, but with those fundamental rights and property which it was intended to secure.
How do they know this is a fundamental right of property, though? What tells them that?
Can you rephrase that?
How does the court know this is a fundamental right to buy and sell property? Yeah, so this is a somewhat easier case, right? This is not about some sort of right to work 60 hours. It's listed. It says property the damn thing, right? You can't be deprived of property. But it doesn't get you all the way. The statute here says, okay, we will deprive you of your property, and the due process is we enact the statute, right? That's the process you do. We've enacted the statute. Right, so the rub is the court still is guessing that this law is unwise, right? Even though the word property is in there, they still have to decide, right? They still have to decide if this law is reasonable, and the court finds that it's not. Some of the evidence they rely on is our favorite Civil Rights Act of '66, right? Remember that one? The Civil Rights Act of 1866, we've talked about that before, which guarantees a right to buy, sell, and dispose of property. One of the black codes, one of the Jim Crow laws, was actually prohibiting the freedmen from buying and selling property. Back then, if you couldn't buy and sell property, you couldn't really exist in that society. Right? That was one of the essential, if I say the bundle of sticks, right? One of the essential elements of being a member of society. Okay? So the majority recognize they can't rely on equal protection, but they declare this law a violation of due process. So in this case, the sort of Peckham opinion comes to help of the black homeowners. It didn't help the women in Muller, but at least it helped the Mr. Warley here in Louisville. that he could buy the house he wanted to. So any questions in the majority? Then we come to Justice Holmes, right? I did not know about this dissent until a couple of years ago. When I found it, I was like, oh my God, right? I was like, I always thought, Holmes dissents in every freaking case in this chapter. Why did he not dissent in this case? Oh, he kind of did, right? We know this because Holmes actually circulated a draft dissent. Right? In other words, he wrote this up himself and said to his colleagues, hey, you guys, you want to join me, please? Maybe? Call me, maybe? Right? You want to join me? And apparently no one joined on to him. So he said, all right, screw it. I'm going to withdraw this. Right? He didn't want to look all by himself and be the only dissenter. OK, you can give him flack. But Holmes makes some points here that I do want to stress to show why this issue wasn't obviously, wasn't obvious, the answer. First off, Holmes is not happy about the fact that the suit was brought by a white person. Right? Again, the setup was this: a white person was trying to sell their home to a black person. That was the setup. Holmes was not happy about that. He's like, the 14th Amendment was not designed to help white people. He says it was designed to help the freedmen. That is an argument which we'll see in a few other cases which has not been accepted, right? Today the court holds that it applies to all people equally, not just the freedmen. Okay. Holmes is also skeptical that this is a test case, right? In other words, Buchanan and Warley are basically on the same side. This suit was engineered by the NAACP to try to get this issue to the court, and they succeeded. Holmes does not like that. He says this is not a real controversy, right? There's no adversity. He also seems to support the Plessy doctrine. He says, look, this law applies equally to white and black people. A white person can't buy a home in a black neighborhood, and a black person can't buy a home in a white neighborhood. What are you guys complaining about? It's an equal law. So Holmes he's embracing Plessy. I think that's the only way I can put it. He's embracing Plessy in this passage. He also notes that the law only affects people who can buy property. You can still live there. These are exceptions for basically servants, right? If you had a servant, they could live in your home. They couldn't own it. All right. So Holmes does what he does in Lochner with his draft opinion, but he sort of pulled it back and didn't publish it. Okay. All right. Questions on Buchanan against Warley? Questions on Buchanan? Very important case that most ConLaw books don't even include because it doesn't fit the narrative, right? The narrative is, well, Justice Peckham was about helping, rich business owners, but in some cases, this doctrine actually helped, break down segregation laws in at least in Kentucky. Yes, Ray?
Test cases.
Yes.
They're manufactured disputes to get it to court to see if they can get the.
That's exactly right.
Can they dismiss it based on it not being an actual real situation?
Okay, so it's a good question. His question was, can a court dismiss a test case because there's no real adversity, right? And let me say a few things about that. You may have studied in Civ Pro that in order to go to federal court, there has to be an injury, right? There has to be some sort of conflict. If the parties are on both sides and there's no adversity, the courts do have the power to dismiss the case, right? Courts can't issue what are called advisory opinions. They can't just opine on disputes. So there are some decisions the court says there's no actual dispute, right, where the landlord and the tenant are on the same side here. This case, though, I think will be harder to toss because there actually is a conflict, even though they agree, right? A wants to sell his property to B. A cannot sell his property to B because of the statute. B then challenges the constitutionality of the statute. That's a perfect test case. I don't see how you can dismiss it. I think Holmes is just cynical. He's like, I don't like this. Right? Because the thing of a test case is it encourages fake litigation, right? I shouldn't say fake, but it encourages like artificial, right? It's not, you're basically putting together parties for the sole purpose of going to court. That's why it exists. Right? At least with Homer Plessy, the guy actually got arrested, right? There was actually like an arrest. But here, A and B were both on the same side. So I mean, it's, maybe they could have tossed it. I don't know. Good question, though. Right? Or like, a student applied to a school, she was denied entry, right? Okay, there's actually some things to challenge. But here, these people are completely complicit. It was a private transaction. Okay, any other questions on Muller? Braden, you want to give me the facts from our last case, please? Adkins versus Children's Hospital.
It's done in the District of Columbia, and they set it up a fixed minimum wage for women.
Women and children. Okay, let me just pause you for a minute. A minimum wage for children? Yes, child labor is legal. No one challenged the children aspect. It just wasn't challenged. The only part of the law that was challenged was the minimum wage for women. All right, go on.
You want me to get into the actual...
Give me the facts, yeah.
So the opinion by Sutherland, basically he was going on about, we're reaching a point where the differences in sex, are closing in. We don't have as much sexism. It's closing in. And I think the 19th Amendment was already passed at this time. So he basically said there's virtually no difference between men and women. Therefore, the act of having a minimum wage for a woman kind of, I believe, violates their right to contract. So therefore, they can't do it.
Okay.
They're basing off the Fifth Amendment, right?
Okay, good. Yeah. So let me unpack that a bit. First off, this case arose in the Federal District of Columbia, not in a state, right? The 14th Amendment's due process clause only limits state action. The 14th Amendment only restricts the states. In contrast, the Fifth Amendment limits federal power. This is from Barron v. Baltimore. Right, so this case is brought under the Fifth Amendment of the Due Process Clause. There's no difference, though. The court treats the analysis identically between the 14th Amendment's Due Process Clause and the Fifth Amendment's Due Process Clause. These cases are treated in the exact same fashion. Everyone with me? Okay. Next, the court has to consider, how do you review this law, right? And I think there are two ways of looking at this law. One way of looking at this law is, well, this is a law that's necessary to help women, right? There are hard economic times, and adding a minimum wage ensures that women have enough money to take home, to feed themselves and feed their families, right? Right? The other way of looking at the law is quite different. This law only applied to women. What does this law suggest? That men are capable of negotiating their own wages, but women are not. Huh? That if a man can negotiate a lower wage, he can get it. But a woman can't. Now you say, Josh, why would someone want a lower wage? Well, if you have a choice between being unemployed or having a lower wage, which would you pick? Right? I don't want to be economic preachy, but the true minimum wage is zero because you're unemployed. Right? That's the actual minimum wage. But if you have a choice between working for less than minimum wage or being unemployed, which would you pick? Men have that option, women don't. Right? Women cannot choose to take a below wage job. And this effectively was designed to keep women out of the workplace. Right? The same way the Oregon law was designed to limit workers' hours in laundromats, the Washington law would keep women out of the workplace. Now, again, for those in the workplace, it was great. You had a higher wage. But this would decrease the number of women who were eligible to work in the first place. And it says, men, you can negotiate a below hour wage. Women, you cannot. Now, Justice Sutherland says the reason why women were not given this power was based on an inferiority. Right? That they're too dumb, that they're too stupid, that they can't embrace their own wages. What about Muller, right? Muller versus Oregon, the case we had from last class, or from a few minutes ago. Didn't Muller, in fact, hold that women were inferior? Sutherland rejects the Brandeis brief. He rejects Muller emphatically. Sutherland was a bit of a suffragist. He actually introduced the 19th Amendment in the Senate. And Sutherland says that since Muller was decided, 1908, the differences between the sexes have gradually drawn closer, right? That the ratification of the 19th Amendment has altered the dynamics. That if women have full political equality, that they can vote for whoever they choose, they too should have economic equality, that they can negotiate for whatever wages they have. Right, again, the part of this case that gives people the most difficulty is why would someone want a below wage salary? Well, they want a job. And sometimes you have to work for scraps to get by. Women don't have that option anymore in DC. Right? So Sutherland's analysis basically repudiates Muller and applies the Peckham approach to women. Right? He extends Lochnerism to now women. Okay? He writes that the freedom of contract, the right of contract, is part of the liberty protected by the 14th Amendment. And that women have equal right to obtain from each other the best terms they can based on private bargaining. Right? Muller proceeded on the theory that the difference between the sexes can justify different rulings. No longer. We cannot accept the doctrine that women of mature age need special protections that men do not. Okay? This law is arbitrary. It forces employers to pay extra money with no connection to what the worker can actually do. Right? There's the means and the ends, right? Why are they doing this? Does there any relationship between the wage and what the person is actually doing? He says this is a naked, arbitrary exercise of power. That has nothing to do with what people are doing. In other words, a wage should be fixed based on what the person's doing, not based on what the government official approves. Therefore, the law is unconstitutional. Okay. Questions on the majority opinion by Justice Sutherland? Question on the Sutherland opinion? I'm just going to, I know I'm running a little bit short time, I'm going to lecture a bit. But anything on the Sutherland opinion? No? Okay. Justice Brandeis recused. Apparently his daughter worked for the District of Columbia government, so he didn't participate in the case. Not that it would have mattered. The first dissent was by Chief Justice Taft. And we've talked about Taft before. He was the only person to serve in both the Supreme Court and the presidency. Right, Chief Justice William Howard Taft. This was the guy who broke the horse's ankles. He was so heavy. Right, the guy was huge, stuck in the bathtub. Justice Taft says, wait a minute. We have Muller, right? How do we get from Muller to here? And he would simply stand by Muller. Justice Holmes also, Justice Taft also says that the 19th Amendment did not change the strength of women. In other words, women are just as inferior as they were when Muller was decided. Again, this is a weird case. It was like, wait a minute, Josh, I'm not sure where I fit on this, right? It's like, I don't like the dissent, but I like the minimum wage, right? You like the minimum wage, but you don't like the reasoning behind it. And I think the way you square that is, if there's a minimum wage for everyone, it's cool. But this was a minimum wage designed just for one sex because they were deemed inferior. So this case always gives students a little bit of difficulty, I think. Okay, questions on the Taft dissent. William Howard Taft. All right, I want to focus mostly on the Holmes dissent because this is where the court would eventually. This is where the law would eventually head. Okay. Holmes also considers means-end scrutiny. Right? Holmes says, what is the government trying to achieve here? Removing conditions leading to the deterioration of the race. What's he talking about there? Oh my goodness. If women work too hard, they can't reproduce. Holmes, yeah, he had a way with words, didn't he? What he's basically saying is if women have these sort of conditions, they'll be unhealthy and they won't be able to spawn. That's a Brandeis brief, right? The reason why you need these restrictions is to make sure women have their primary place, which is reproducing. That's it in a nutshell, right? So if the goal of this law is to keep women reproductive, I don't know what to say, then that's reasonable to have a limitation on their hours and their wages, right? The means, this hour law, is a reasonable way of achieving the goal of keeping women healthy so they can reproduce. right? It's you might like the dissent's outcome, but the reasoning is like kind of icky, you know. Holmes continued, when so many intelligent persons who have studied the matter more than any of us can think the means are effective and worth the price, the law is reasonable. In other words, majority rules. If the majority in D.C. vote for this law, if Congress approves it, that's good enough for me. And if the majority thinks that this law is necessary to keep women healthy, that's good enough for me. Now, Holmes believes it, right? He's not just assuming that. He actually, I think, firmly believes that women need to be healthy to reproduce, that this is a good law, right? If you can imagine Holmes thought, man, this law sucks, but I'm going to defer. It'd be a little bit different. But he actually likes this law, right? I think he's actually skeptical of the Baker law, right? With the Baker law, he says, well, you know, maybe I can be persuaded this law is okay as a policy matter, but I'm not going to do it as a judge. Here's like, yeah, we need this one, right? He is wholeheartedly supporting this law as a policy matter. Ditto with the segregation ordinance. He says, yep, it's equal, right? Blacks live here, whites live there, it's all cool. Lochner's like, well, maybe I can be persuaded this law is okay. You know, I don't really know. But here in Muller, at least, in Adkins, he's like, yep, this law is good. Holmes also reiterates his arguments from Lochner again, right? That the word liberty in the Constitution is not defined. There is no liberty of contract in the text. All law restricts what people can do, and contract is nothing special. The courts, you're right, should not be involved in telling legislatures how to govern based on this nebulous, vague standard of liberty of contract. Finally, he says, we've already said you can restrict the hours, why not the wages, right? Wage and hours are basically the same idea, right? If you tell someone you can only work 10 hours or you can only pay someone X dollars an hour, you're saying the exact same thing. He writes that Lochner should be allowed deserved repose or rest. In other words, he just would overrule Lochner. The Holmes opinion, again, was a lone dissent. But after the New Deal in the 1950s, the court would eventually embrace, after the New Deal in the 1950s, the court would embrace Holmes altogether. But in the next period, the courts are sort of all over the place. We have our situation here today with economic cases. In our class on Tuesday, we're dealing with personal liberty cases, right? And we have this sort of debate, right? We know that the framers of the 14th Amendment like property rights. They talked about rights of contract and selling property. What about when we're talking about other types of liberty? For example, the right to raise your children, or the right to see where your kids go to school, or the right not to be sterilized by the state, right? How are we to know what liberty is? What is liberty? And the cases for next class, I'll bring that home. Any questions? All right. Yes, Matt.
Question. I guess it is a question.
Question, more of a comment, right?
Yes. Is a $0 minimum wage? Isn't that just slavery? I mean.
No, I mean, but you're not working.
Right, because if you're not working, then it's not a minimum wage. You're not trading your labor for something.
It was a rhetorical point.
Right. So, okay, I get it.
The true minimum wage is 0 because it means you're just not hiring a person.
Sure, but
Yeah.
that's not. You're not trading your labor for nothing.
No, that making someone work for $0 would be slavery.
Yeah.
Thank you.
Okay.
Okay. Anything else? Yes. That's exactly right. This was a law to put women out of business. It was designed to keep women in the work out of the home, right? It sounds great, a minimum wage for women, but it results in them being unemployed. Yes. Anything else? All right, I'll see you all on Tuesday. Have a nice weekend. And I'll be around today for maybe about 2 or 3 or so.